I confirm that we had the discussion before, and if it pleases the court to grant leave.
Then thank you. Justices, we've prepared full written argument, and we stand by all the arguments that are contained in our heads of argument. Let me just try and give a roadmap as to how it is we intend to approach the matter. In paragraph 83 of our heads of argument, we suggest that there are two types of orders that should be granted. One is a simple prayer that says the appeal is upheld with costs, including the costs of 2 counsel. And the other is a prayer with 5 subheadings. And for today's purposes, we are only going to ask the court to grant 2.1, 2.4, and 2.5. And we're going to submit at the end, when it comes to remedy, that 2.2 and 2.3 are not necessary, and we do not move for those orders. The basis of our case is that it is accepted, we submit, that the notion of disguised extradition is unlawful in international law. It violates the Constitution, and we submit that if ever there was a case on the facts for a disguised extradition, this is it. The facts present, we submit, clearly demonstrate that there is or was a disguised extradition, and to demonstrate that, we are going to ask that our argument be divided into 6 chapters. I'll take the court through the chapters after I beg leave to hand up a small bundle of the authorities that I'm going to in particular refer to during my argument. It is something that we debated in chambers, and perhaps then you will see the 6 chapters divided into the contents page of these further submissions. We've prepared it just to make things easier. There's one case in this little bundle which is not referred to in our heads of argument, and I'll explain why. It's a case dealing with remedy, which only arose after our learned friends' heads of argument were filed. And I'll explain how it came about that that case is of relevance today. But the court will see this, in the bundle there are 5 headings. One sees the rule of law and public opinion. Those are items 1 to 3. Then the importance of extradition and the distinction between deportation and extradition, and there are 3 items. Then a pleadings chapter, and the last is a remedy chapter. Those are the 5 headings. There's one other heading, perhaps I should just highlight, which we haven't included in this bundle as a separate chapter, but that's on the question of waiver or the consent to extradition. But for purposes of that chapter, included in the bundle is the Muhammad case, which is item 4, which is pages 14 to 20. And in particular on page 18, there is a paragraph in the judgment of the Constitutional Court, it's paragraph 64, which we submit should dominate this court's thinking when it comes to the question of was there consent by the appellant to be, and I use the word very carefully and very specifically, handed over to the South African government. Handed over. On the same day, a notice of prohibition was signed, and she says, it's not contested, that she saw it for the first time, that she saw the prohibited immigrant's notice for the first time when it was filed as part of the papers in this case. There's no suggestion that it was given to her, that she saw it, that she knew her rights. There's none of those issues. The simple issue that they raise is on the papers, which I'll come to when I deal with that chapter. So let me turn to the first chapter, which is the rule of law and public opinion. We submit that in this case, our experience tells us that there's an elephant in this room. And the elephant is that the appellant did a bad thing. She committed a serious crime and she must pay for it. That's public opinion. It's hard to find anybody, not that I live in the Twitter sphere or the X sphere, where one looks at the News 24 comments on, there's an article on TV or the news, and then one sees people comment. And almost unanimously, the people say, she must do the time that she deserves. And that's what we would call the public opinion balancing. On the other hand is, what is the law? What is the rule of law? What does it mean? And should the rule of law bend to what the public think should happen? And we have in our bundle 3 little extracts. And the first is the first case of the Constitutional Court, S versus Makwanyani, where there's a heading, the public opinion. It's on page 2, and perhaps I should just take the court through these various headings. And the Jaskelson P deals with public opinion. And he says the Attorney General argued that his was cruel, inhuman, or degrading depends to a large extent upon contemporary attitudes within society, and that South African society does not, etc. And we emphasize what is said in paragraph 88 and 89. Public opinion may have some relevance, but in itself is no substitute for the duty vested in the courts to interpret the Constitution and to uphold its provisions without fear or favor. If public opinion were to be decisive, there'd be no need for constitutional adjudication. Then I go on a little bit lower at letter E. The very reason for establishing the new legal order and for vesting the power of judicial review of all legislation in the courts was to protect the rights of minorities and others who cannot protect theirs. And then the important 2 sentences. Those who are entitled to claim this protection include the social outcasts and marginalized people of our society. And then the sentence which would always dominate thinking in a case dealing with crime. It is only if there is a willingness to protect the worst and the weakest amongst us that all of us can be secure that our own rights will be protected. Let me emphasize, there must be a willingness by the courts to protect the worst, the bad criminals of society. There needs to be protection, and the weakest amongst us, that all of us can be secure. And then on to the next page, in paragraph 89, there's further dealing with this question of public opinion. I do want to jump forward to the case of West Virginia State Board versus the quote from that case versus Barnett, where Justice Jackson said the very purpose of a Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, etc., etc. Our rights may not be submitted to vote, they depend on the outcome of no elections. And we know we're living in a world where elections play an increasingly dominant role in the public space. And especially in this time, with elections playing the role that they do, throughout the world, in every country, it's so important that courts ignore that which public opinion should dominate. And we move on to the next case that we, in this little bundle. It's a case called Tsebe, which the court will have regard to not only for the proposition of this public opinion elephant in the room argument, but also when it comes to remedy. And there, the respondents in the Constitutional Court had succeeded in the High Court, but before the full bench, and the Minister of Home Affairs, together with, I think, Justice, argued that they should be deported, or in that case, be allowed to be deported or extradited to Botswana. And there was a problem because Botswana would not give an undertaking of no death penalty. And I remember I was in the case for the respondents, and one of the questions that was posed was, well, you have people who've committed a brutal murder. Whether they're South Africans or not is not an issue. What happens if we say they can't be deported for whatever reasons? And my answer was, which is now contained in the judgment, that's the price we pay as a society for having the rights that we have. And if individuals who've committed brutal murders or committed terrible crimes have to go free. That's the price we pay by having a constitution. And those are the words that then acting Justice Zondo, who became the Chief Justice, now retired, said. Between the letters E and F, he said, one of those things that no matter who the person is and no matter what the crime is that he's alleged to have committed, we shall not be in any way party to the punishment, and we will not hand such person over. The path that we as a country have chosen for ourselves is not an easy one. Some of the consequences that may result from our choice are part of the price that we must be prepared to pay as a nation. For the advancement of human rights and the creation of the kind of society and world that we may ultimately achieve if we are to abide by the constitutional values that now underpin our new society since the end of apartheid. And we would say this is part of this introductory chapter. Public opinion, there's a law here. And we say, we move on. Just in passing, on the next page, page 8, next to this G, we see that first the alleged killing was brutal. In Botswana, they talk about this. So these are really not good people. And then the next case that we've included is Alvarez Machine, which is referred to in our heads of argument, and it's referred to in the Mohammed case. And we would ask, and this is important from a different perspective. This court knows very well that previously it had ruled in the Ibrahim case in a particular way. And what happened was there was an abduction by the apartheid government of somebody in Swaziland, and this court, overturning the High Court, found that that abduction from Swaziland divested the courts in South Africa of jurisdiction. And you see reference to that case, the Ibrahim case, on page 12. It's reported in April, June, South African law reports. This is on page 12, in the U.S. Supreme Court judgment. And what happened in the U.S. Supreme Court, there were nine justices in the U.S. Supreme Court, and Dr. Alvarez Machine was in Mexico. He was alleged to be part of a drug conspiracy, involved in horrible murders and the like. And the U.S. Drug Enforcement Agency, a U.S. government agency, abducted him into the U.S., and he took the point, I was abducted, disguised extradition, or whatever it was. Therefore, the criminal trial courts in the U.S. don't enjoy jurisdiction. The case went all the way up to the Supreme Court, and there was a 6-3 split. The 6 said, the courts in the U.S. do have jurisdiction. The 3, the dissenting minority, found that the courts in the U.S. would not exercise jurisdiction. And the importance of the dissent, which we would emphasize, are the words that Justice Stevens said dissenting. He says, and starts on page, the dissent starts on page 11, and he says the court's admittedly shocking disdain for customary and conventional international law principles, and he says with reference, is thus entirely supported by case law and commentary. It's not. Then he goes on, syllabus 4. As the court observes at the outset of its opinion, that means the majority. When he talks about the court, he's meaning the 6. There's reason to believe that respondent participated, this is Dr. Alvarez Machine, in an especially brutal murder of an American law enforcement agent. That fact, if true, may explain the executive's intense interest in punishing respondent in our courts. We could almost have that here. That here, the appellant is alleged to have done horrible things. And then he says, if true, it explains why the executive has an intense interest in punishing, in that case, Dr. Machine. Such an explanation, however, provides no justification for disregarding the rule of law that this court has a duty to uphold, that the executive may wish to interpret the treaty to allow for an action that the treaty in no way authorizes should not influence this court's interpretation. Indeed, the desire for revenge exerts a kind of hydraulic pressure before which even well-settled principles of law will, and then see what he said with reference to some other cases. And I turn a bit lower. And here we have, this court should be proud of its legacy. I will come to December, I will come to Mahala. But what the justice says is this: the significance of this court's precedents is illustrated by a recent decision of the Court of Appeal of the Republic of South Africa. That's this court in Ibrahim. And he says, based largely on the understanding of the import of this court's cases, those were the oldest Supreme Court cases in the US, including our decision in Kerr, and there's a footnote to the Kerr decision. That court, the South African court, held that the prosecution of a defendant kidnapped by agents of South Africa in another country must be dismissed. The Court of Appeal of South Africa, indeed, and this is the important sentence, I suspect most courts throughout the civilized world will be deeply disturbed by the monstrous decision of the court announces today. For every nation that has an interest in preserving the rule of law is affected directly or indirectly by a decision of this character. As Thomas Paine warned, an avidity to punish is always dangerous to liberty because it leads a nation to stretch, to misinterpret, and to misapply even the best of laws. To counter that tendency, he reminds us, he that would make his own liberty secure must guard even his enemy from oppression. For if he violates this duty, he establishes a precedent that will reach to himself. And then I turn to the last case on this point. I welcome questions. Excuse me? Yes. Well, no, Justice Zondi. We submit that if one turns to this little bundle that I've just given the court, one sees in paragraphs or items 7, 8, and 9, 3 items dealing with pleadings. And we're going to submit, and do submit, that in assessing the facts, there aren't 2 diametrically opposed versions, as your Lordship has put to me. There is a combination of facts that, bearing in mind the onus and bearing in mind various other principles that I will come to, would suggest that the true facts are these. From the 6th of April, she was identified as being, well, on the 6th of April, she was arrested in Tanzania. On the 8th of April, it came to the attention of the South African authorities that those persons, the 2 persons, I think there was a third from Mozambique, who had been arrested in Tanzania, maybe Mr. Bester and the appellant. So on the 9th of April, a delegation of South African officials traveled to Tanzania to determine whether that was true or not. It was Easter, so on Monday, the 10th of April, they had a meeting at the hotel. And various things happened at that meeting, and I'll come to it. But the important is that within 48 hours, she was on a chartered plane having been handed over to South African officials. And the question arises, which is not answered on the papers and not answered in heads of argument. On what legal basis were the police and the Home Affairs officials entitled to leave Lanseria Airport on the 12th, charter a plane, and arrive in Tanzania to do anything? We'll come to what they actually did, but when the South African police's powers end at the border of South Africa, the Department of Home Affairs officials, Mr. Madiri and the others, their power is circumscribed, we know from FedSure, by the law. And this court will have to interrogate, we submit, what powers the police or Home Affairs exercised the moment they left the borders of South Africa on the 12th. And I'm going to invite the police respondents and the NPA to indicate to the court on what legal basis were they there. And they use the word escorting the Department of Home Affairs officials to Tanzania. That's number one. So, yes. Yeah. In the notice of motion, in paragraph 2, we ask for a declarator that the applicant's apprehension, etc., on the 7th, and we do say by the police, sorry, no, we don't say by the police, so that becomes later. Apprehension, arrest, and abduction in Tanzania on the 7th, and subsequent transportation to South Africa and purported arrest and to be declared wrongful and unlawful. Yeah. In paragraph yes, no, I accept that. Yes. Yes. I'm going to come to why I'm going to submit. Yeah, there's been no amendment under Rule 28. I accept that. Yes. Well, I'm going to come to it. I'm going to come in the cases. I can't but disagree. I can't but not agree. I agree. I absolutely agree. And that's why we've got some cases on pleadings. No. But in I accept that. I can't but say. I accept that. Well, the police took the point that Home Affairs had not been joined. Yes. Yes. Absolutely. Correct. That's what they said. I'm going to come to that, but in order to... Sorry. No, I've got two answers. Firstly, it's not entirely untenable on the facts. We will leave that. But more important... Excuse me? No. The police's version and Home Affairs version is entirely untenable. That's the first proposition. The second proposition, which is where I was going to come to when it comes to the pleadings point, is this. May I ask that the court turn to page 39 of the little bundle? Page 39 of the little bundle. The court will see that that's an extract from a judgment of this court called Jibai. Prior to Jibai, the previous case in the bundle on page 35 is a case called Zealand. But Jibai and Zealand make the same effective proposition, which is on page 39 in paragraph 22. And Justice Gorvin, I must accept that there could be regarded as some type of distinction between the facts in Jibai with these facts. But for purposes of this case, that distinction is without a difference. And what he said next to the letter D, moreover, the respondents alone know the true facts concerning the detention and deportation. The appellants have in their founding affidavit squarely placed the lawfulness of the arrest, detention, and deportation in issue. Now the important sentence, the respondents must therefore prove that they acted unlawfully. So when Justice Gorvin, you put to me, well, what do the founding papers say, and leave it at that? The founding papers say squarely, the respondents, at that time the police, acted unlawfully, I'm in detention unlawfully. That's what they say. And this court is... No. 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 No, with regret. I'm sorry, Justice Gorvin, Justice Ronnie, because the way we understand Zealand, if a woman makes one sentence in a founding affidavit and says, I am detained unlawfully, and I ask the court to give me relief to be released, as we understand the cases, that's good enough. Now, well, I'm going to come to I haven't been given an opportunity, but I would like to, at some point, forcefully argue that the police had no business being in Tanzania at all. They came into the picture on the 8th of April. Yeah. Well, the 6th of April, the 7th of April, 6th of April. Well, now it turns out it's the Tanzanian police, but she didn't know that, and that's why I keep saying, what Jibai and Zealand and the authorities have always said, she doesn't say, what she says in her founding affidavit is very clear. Yes. Excuse me, Mike, that's my thought. No. I haven't been given a chance to get that. Please. In the founding papers, in paragraph 1, she says, these are her words, presently, I'm illegally detained at Bazaar Makate Correctional Center in Kroonstad. That's what she says. Yes, but I'm going to come... No, I'm going to argue that the facts demonstrate, not just a question of untenability argument, that the facts here show that the police were involved in her arrest on the 12th. No, they're facts. No, Jibai says what Jibai says. I can't move away from Jibai. Jibai says the respondents must therefore prove that they acted lawfully. No, I'm asking you to do what... No, I'm going to ask that the court does what Zealand and Jibai did. Well, not Jibai, but Mr. Rush. Yeah. Whoever. No. Sorry, Justice Catherine Sitliani, I think you said something to me. It's not a question of justify. The respondents, there's an allegation that the police acted unlawfully here, in this case. And, I accept those difficulties as a matter of principle. I can't run away from them. I can't. But we would submit that, like in Jibai, and let me just go to the pleadings point. No, it wasn't. It was. Jibai. It wasn't. It wasn't. It wasn't. And in the pleadings, what it was said, I just need to find it. In the pleadings, what happened was, Jibai, nobody knew where Jibai was. So Mr. Rashid made the affidavit. And what this court said is it's for the respondents to explain what happened, because they are the ones who knew what happened. My client gets arrested. She thinks it's the South African police. She might be completely wrong. And she comes to court and she says, I was arrested by the South African police. It turns out she wasn't arrested by the South African police. She was first arrested by the Tanzanian police. I have to accept that. And then, in Tanzania, on the common cause facts, she was taken into custody, I'll use those words importantly, by South African government officials, including Home Affairs officials, and we're going to submit the police as well. By agreement with the South Africans. So we have an agreement. We don't have to prove that at all. They've proved it themselves. Firstly, we don't have an onus to prove that. That's the first submission I make. Number. No, because deportation is a unilateral act, as we know. And the papers make it clear that what happened here was a bilateral act between two states. So on the circumstance of this case, yes, absolutely. Yes? With respect to Justice Mahoko, we know that Mohammed tells us, and the authorities, international law, and always tell us, deportation is destination neutral. And if she could go to China, to Chile, to Cameroon, to any country in the world from Tanzania within 3 days of the 12th of April, by the way, under escort, that's her choice. She had a right. But no, what happened here was the Tanzanians and the South Africans, as you put it, with respect, Justice, colluded, or Justice Catherine put it. Yeah. There was clear. I don't. Near Maring. Yes, they say there was an agreement. This is what they should have done. This is what they should have done under international law, and they should have. Firstly, they should have served the prohibited notice on it. They didn't. They didn't. She didn't even see it. On the 26th of May, 2023, when she saw it when it was attached to the. South African court can rule and must rule that what the South African officials did was unlawful. Yes, sir. Sorry, I understand. Okay, yeah. No. Yes, no, I accept the question. Accept the question. And so the question has we would submit some difficulties within it. One, if they decided to deport her, that has certain consequences. I'm going to come back to them. But you're asking me the question, they had decided to deport her and they knew that she was facing certain charges in South Africa. Then they had two choices, either to wait for the extradition request and deal with the extradition request as the law provides, and then let an extradition request be processed through the system, through the SADC protocol on extradition, which South Africa and Tanzania are parties to. But if they decided not to do that, in other words, to avoid assisting, and I use the word assisting because that's what extradition is, avoid a bilateral event, they should have, one, served the prohibited immigrants notice on her, on the 12th, but that's when it was issued, they say, and she had 3 days to leave. She could have left and gone anywhere she could have been entitled to go. And the fact that Justice Guthrie, your question actually makes my case, because you're saying to me, what should they have done now that they knew that there were charges for purpose of deportation? Nothing different as if there weren't charges. That's the point. Excuse me, sorry. Treaty or whatever it is, yes. Yes. No, it's not more legitimate, it's illegitimate on its face. Justice Guthrie, sorry, I do apologize. No, you made a very good point. Your question. No, it's not a point in my favor. It demonstrates exactly what we're arguing. And you asked the question, and the question itself makes our case. And you know what happened on the 10th. You know exactly what happened. The Tanzanians said to South Africa, are you going to bring an extradition request? And what did the South Africans say? It depends on you. It's just unacceptable on any level. And we talk about Olmsted, and they say it was. Yes, of course. Extradition one. Well, maybe or maybe not, but the question is this, that we don't get into that question for a different reason. If they were your question is a very good question. Now, and I have to say this because what's being put to me, and it's an important question. No, okay, so with the question... Yes, absolutely. Well, we didn't know. That's the Chiva pleadings point. We couldn't have known. We never. Can I just say this? I'm going to come to the pleadings principles, but I find many. And that point is made. That point is made directly in Muhammad, where it says sometimes they can coincide in effect. And maybe I should read you the paragraph. Where the question is, will you... Sorry, I want to come back to this. It's not, this case, sorry, In Muhammad, what they said was, the court said, deportation and extradition are different. And sometimes they coincide in effect. And in practice, the courts must be careful to determine whether that coincidence crosses the line to become a disguised extradition. That's what, as we understand the principle. Yeah. But your question, that's why your question is so important to me. Yeah, well, your question was so important, Justice Catherine, and I'm not just saying it in my favor, because you said to me, when they were deporting her and they knew that she'd been accused of crimes in South Africa, how would that change the things? It shouldn't have at all. Nothing. And the fact that it was even in their heads is a factor that goes to our case. Let's say, and you asked me, and I haven't answered the question because I haven't been given a chance. What should they have done? And I'm going to answer it like this. Whether they knew or didn't know, whether the appellant or the person was accused of crimes in South Africa or otherwise, what they should have done, he said, here on the 12th of April, whatever time it was of day, here is your prohibited immigrant notice. You have 3 days to leave within 3 days. Full stop. That's what Muhammad, that's what international law tells the world must happen when it comes to deportations, Justice Mahmoud. That's how it works. International law says when it comes to deportation, the deporting country, and this is the words of Muhammad, doesn't have any interest in what happens to the person once the person has left their state, rid the country of the alien. So the 3 days off, so she had until the 15th, on any version, the 15th of April, 3 days to leave. But no, South African agents, after an agreement, and we emphasize the word agreement, this court cannot run from the word agreement in the third Secretary of the High Commission's affidavit. There was an agreement. But deportation can never involve agreement between two states. Never. And I want to come back to the pleadings point. Excuse me? Sorry. I must for purposes of the pleadings. That's what the pleadings say. Yes. I can't, I run from it. Paragraph 7 of the pleading. So it's page 7, paragraph 7. Justice Gorman, sorry, it answers your question if one has regard to what this court said in Jibhai. We're going to submit on the 12th. No, on the 12th it happened. It happened. In the reply, well, we don't say that. That's what they say. They make out our case.
Well, your case must be made out of the filing papers with the notes and motions. Those are the feelings. That's the course of the action. And that's what you bring to court on.
Yes. Now, I was on page 39 of Jibba. With respect, now please, I know. Sorry, I was answering you, Justice Gorman, and then I was pulled back to the Justice.
I might just say I don't have any difficulty with that deportation is an act of neutrality in the sense that you say all that you're required to do is leave one country.
No.
I also don't have any difficulty with the Tanzanian police, if it was there, arresting her for being an illegal immigrant in their country. I'm pretty sure you can't have a problem with that. And then deciding at some stage, whatever stage, to issue a deportation order. If that order then says you've got 3 days, you've got 3 days.
Yeah.
So That's where we've got so far in terms of any deportation.
Well, let me-
I
pleading.
said that does not give any rights necessarily to foreign authority to come to that country without consent. That's where we might get to if
we get there.
the argument succeeds further down the line than I'm going at this stage. I have no difficulty that unless there is consent to say, well, I'd like to travel home with you, whatever it might be.
Oh, that consent, yes.
Yeah, correct. Then the foreign authority, in the light of a deportation order from another country, has no rights.
So if there's a deportation, if I understand the question.
So Tanzania issues a deportation order that does not authorise any foreign country to do anything without someone else's consent, without the person's consent.
No, I go further than that. First, the answer is yes, but there was no consent here, but that's it. We'll get to that argument. But more importantly, even if the person consents, that doesn't turn the conduct of the foreign authorities on that sovereign state's land into a lawful, authorised act conduct.
No, if someone arrives and says, I'll transport you home, yes please. I mean, that's as simple as that.
Someone,
let's just say someone.
No,
If someone arrives and says, I'm prepared to transport you home, would you like to come with me? And you say yes. That's not any disguised extradition at that point, is it?
Well, I'm going to disagree. I'm going to say it's unlawful.
You're entitled to agree to that.
No, I don't agree with it. I don't agree. Well, welcome to
But
it.
you serve a deportation order, and someone says, well, you've got the order, you've got to leave the country in 3 days, I've got the aeroplane, you want to jump on with me? I'm not saying those are the facts necessarily. You can't have any argument with that, surely.
I'm going to argue with it. I do have an argument when it comes to the foreign authorities, because the foreign authorities, well, I can't speak for all foreign authorities, I speak for South African authorities. The South African authorities need a legal basis to be able to offer her lift back. And if they don't, the consent is one which is an unlawful consent as a matter of principle. One can't say, well, that's why, Justice Gore, when you said someone, if it was me, and I hired a chartered plane, with my money, with my private jet, or my private, which I could never afford, or whatever. The question is, this is South African government doing it. And the South African government needs a source of power. We'll get to that. But I do want to please, I know you pushed me on the pleadings point, and I have to read this one sentence.
Yeah, well, I am pushing you on that point, so I want to give you every opportunity to...
And I haven't even, pleased. So in paragraph 22 on page 39 of our little bundle, and I started reading and then I was, it's page 39.
The bundle just...
Yes, that bundle, yes. This is page 39, it's paragraph 22. It's the third sentence after the footnote 10. And I know, Justice Gore, I had started reading the paragraph, but then I was pulled away. So
I think my sister took...
Yeah, no, I'm just making... it's the third sentence, which is the sentence that we would submit, puts a hole in the debate, it puts a cap on the hole that it's a cap on the debate that we've been having. And because every deprivation of liberty is presumptively unlawful, the respondents bear the onus to adduce sufficient facts to justify the actions. And here's the important sentence, which we would submit, puts paid to the difficulty that the Justice Gore, when you identify with me on the pleadings point. This is so also in motion proceeding as an exception to the general rule that the applicant must disclose its case in the founding as well.
I have no difficulty with that proposition, but we've still got to prove a deprivation of liberty by the person you accuse of having deprived of liberty. That's what you've got to prove. Before any onus shifts about whether it's justified or lawful or unlawful or whatever else, you've got to prove a deprivation of liberty. Do you not?
She has.
Well, that's for me the $50 million
Well, can you just read the next sentence?
To prove the deprivation of liberty by the South African.
No, well, then read the next sentence. There's good reason for this approach. This is the exception to the rule. Especially in the present case where a person on whose behalf the application was launched is alleged to have been disappeared and unable to oppose an affidavit. Moreover, and this is the important point, moreover, the respondents alone knew the true facts concerning the detention and the deportation.
No, but she makes
How could she know?
She makes up the case that South African police arrested her on Tanzanian soil.
Yes.
She even identifies people.
Yes.
But that case flies in the face of the respondent's version. So I'm talking about the deprivation of liberty now. Forget about the lawfulness or unlawfulness. She's got to show she was deprived of her liberty by the South African police, does she not?
No, but I'm answering it like this. Well, because I'm answering it like this. She's got to show that she was deprived of liberty, number one.
Yes.
And she does that. She says so, and there's no dispute. She was arrested in the time frame. She was handed over to the South African authorities on the 12th. It's common.
That's a question in the past. You said that she has shown that she was deprived of her.
Yes.
Who deprived her?
No, I'm coming to this. She says...
So it's important that we deal with the
Yes, okay. So there are three actors who deprived her. Three. The one was the Tanzanian authorities. I can't get away from that.
She was arrested in Tanzania.
No, we accept that. Okay. Two, the police. And I'll tell you when, I'll say when. And three, Department of Home Affairs.
All right.
Now, the question then becomes this. If I'm right on that, and I accept that if I'm wrong on all that, well then, obviously the appeal can't succeed, obviously.
So the police, whether or not she was deprived of her liberty by the police, you accept that's a factual dispute?
No, I'll explain why. I'm explaining why. The police say the following, and I need to turn to what they say and what the pleadings will say. The police say the following.
Just refer us.
The police say that they didn't have any role in her handing over, and they were only there to escort the DHA.
Yes.
That's what they say. Then the DHA filed an affidavit, in a sense, not inconsistent with it, but the basis upon which they say they acted, which includes the police, will demonstrate, we submit, that the only tenable version that can be accepted is the police were party to, and this is why I kept in 2.1 of the heads of argument prayer, the police, because we could have taken it and said just Home Affairs, but the police were there. So on page 141...
Well, that would be faithful to the case you make out in the final page.
No?
The 2.1 involving the police. Not the DHA. Anyway, that's a different issue.
So on page 141...
Yeah, sorry, let's go there.
141. This is the DA. This is Mr. Matthews' affidavit. This is what he said. And the police can't get away from this, even though they. This is the version, and it's the only. In view of the reports that Bester orchestrated an audacious prison escape, and was regarded as armed and dangerous, this is the Home Affairs, decided to enlist the services of a special task force of the police and officials of correctional services. This was not a foreign concept, full stop. Immigration officers exercise powers when the need arises together with members of SAPS. And the question, obviously, that a court will scratch its head about is, well, what authority is for that? And what's the answer in the next paragraph? And I'm going to take the court to that provision. In fact, Section 41 of the Immigration Act places the responsibility of performing statutory functions and powers on both the immigration officers and members of the SAPS. Section 41. I would like the court to read it, paragraph 53.10 of our heads of argument. And there are two problems with it. And I say deep problems. The one is, South African legislation, unless expressly provided, there are three problems actually. The first is, South African laws, unless expressly provided within the law, doesn't have extraterritorial application. That's problem number one. Problem number two, the section itself is contrary to anything that Home Affairs could possibly have done in Tanzania, because it talks to certain conduct in South Africa as principle. And three, it sucks the police into their difficulty. Because
I have no difficulty with the fact that they weren't authorised. They could not be by Section 41 or anything else to do anything in Tanzania.
But and the police, sorry.
But you've got to show the police arrested on Tanzanian soil. In other words, deprive her of her liberty. The police.
Well, I'm just getting.
The police.
No,
I see that.
No, I accept that. I accept that. So the police were there to escort.
I don't see any proof on the respondent's version that the police arrested her on Tanzania soil, and that's the case you make out of the example. And that's where there's a factual dispute, and if there's a factual dispute, it must be resolved in favour of the respondent.
No, I'm going to come to that. I need to come to that, please. But before I get to that,
arising from my brother's question, you refer us to paragraph 22 of 141.
yes.
The involvement of the police, that is in relation to Esther.
So excuse me.
If you read paragraph 22 correctly, because I say in view of the request that the statement which has in the scheme
Yes.
and was regarded armed and dangerous, I decided to this service is a special task possibly of the
That's
state.
correct. That's
So that allegation is made in relation to Esther. What did they do in relation to?
So what happens is this. I thank you. But the next paragraph then explains. Sorry, I need to. This is a nuance point, and it might be difficult, but I need to explain it. When Home Affairs acted as they did, they enlisted the services of the police to, on the police's version, to escort Home Affairs. That's what the police say. And the police say they had nothing to do with it, in the true sense. That's what they say. But at the airport, when the third secretary recalled that the Tanzanian authorities handed over the appellant to Mr. Matthews, I presume, or Home Affairs, and sorry, I got that wrong. The Tanzanians handed over the appellant to Ms. Moreng. Ms. Moreng then handed over the appellant to Mr. Matthews. When Mr. Matthews received the appellant, he did so with the police around him. That's what he said, simply put. And the question then arises, what were the police doing there?
She wasn't handed over alone. She was Mr. Best as well.
There could be, we don't know. We don't really, well, they say, but the point is these facts and what time it was, how it was, are all within their knowledge. And they're cryptic about it. But I will come to the pleadings point about.
But are you saying that the DHA was impermissible for them to draw in the help of the police
Yes.
to escort
Yes.
the appellant and Mr. Bester back to the country?
I'm going to invite Mr. Stellenberg to indicate on what basis the police were in Tanzania. I'll be invited by him. Let's say I travel to Tanzania tomorrow, me. And I'm scared because there's somebody that wants me there. I can't enlist the South African police to come and assist me. On what basis could
Yes,
it?
but that's not your case. You're saying that she was unlawfully abducted
No.
and arrested. I mean, so
It
even
is.
if they were there unlawfully,
Yes.
but they never do the arrest.
So what were they doing?
Well, they were there to escort her back. There's a whole big difference between escorting and arresting.
I hope.
There's nowhere in the papers that appears that she was arrested by the South African police.
No, let's accept, for purpose of the debate, that she was arrested by Home Affairs at the airport.
Well, she wasn't even arrested by Home Affairs. She was handed over to the High Commission. From the High Commission then handed over to Home Affairs. But she was arrested by the Tanzanian authorities.
Sorry, I have to say, I'm going to make
But I
one.
thought you accepted that earlier on.
No,
And I
I'm
thought
making
that-
the point that you made the
that
point,
she was-
Justice Catherine, that she was never arrested by Home Affairs, she was just handed over to them. Huh? We would sit on that.
Well, they transported her back to South Africa. The police escorted her.
What happens if she said, no, I
So
want
what,
to
there
go to
was an
Chile?
arrest and another arrest and another arrest.
No. There was,
That's what we're trying to understand.
No.
When did the arrest take place?
there are 3 arrests. The one arrest is when she by the Tanzanian authorities.
Okay.
That's the original arrest.
There are 3 arrests.
There are 3 arrests, yes.
The first one is
The 6th of April by the Tanzanian authorities. The second one is on the 12th of April under what Home Affairs. May I read section 41? The second one is a section 41 arrest. A section 41 arrest late in the evening of the 12th of April. And then the third arrest is at Lancero by what the police say is a section 43 warrant execution.
I accept that they thought they had the authority, and I accept that they didn't have the authority.
To do what, Justice?
To do anything on Tanzanian soil without her consent.
Let's
go that far.
no, but it goes deeper than that. Please, I need to say that. Section 41 speaks to certain powers which they say they exercise.
Oh, no,
But let's see what those powers are. No, but what are those powers that they say they exercised? You've got to look at what. Let's read it. That's the point. The important words in Section 41, which we submit, should dominate how the court views what Home Affairs say they do. This is what it says. This is what they say. It's not like we don't even, I mean, the Jimite point, how could they know? They know, we don't know. When so requested, this is paragraph 53.10 of our heads. When so requested by an immigration officer or a police officer, any person who shall identify himself or herself as a citizen, permanent resident, or foreigner, and if on reasonable grounds such immigration officer or police officer is not satisfied that such person, we've underlined and bolded the words, is entitled to be in the Republic. That just shows that Section 41 had no application. But leave aside that for a moment. I want to go further. I want to, please, this is important. So they ask the person for their identity. They then can interview the person, which was not necessary here because they knew who they were dealing with. What may they then do? And this is what they say they did. They say such immigration officer or police officer may, and Justice Cathy, we would disagree with you if you say that this is not arresting, take such person into custody.
But that's an illegal immigrant into South Africa.
No. You're interpreting Section 41 no, it's an illegal immigrant in South Africa. Correct. But they say that that's what they did.
No, we're wrong.
No.
They misconceive their powers.
No, they misconceive their powers, but in misconceiving their powers, the power that they were misconceiving, they thought, absolutely wrongly, on a range of levels, that what they were doing was taking such person into custody.
And if, in fact, she turned around and said, I refuse to go with you,
yes,
they would have had to release her because they had no power. They might have thought they didn't have to release her, but they would have had to. But now this is Home Affairs we're talking about. We've still got to get back to the police.
And what are the police doing then?
The police are standing by and saying, well, here we are.
Justice
no
Gordon,
evidence that the police were involved at all in any of that, and we'll come back on the
let me answer it like this. I'll answer it in two ways. Firstly, if the court is inclined to take the view that the police should just stand on the side around Home Affairs, here we are, and suggest that that has got nothing to do with the taking into custody of the appellant, we say that's not the world that we suspect court should go to.
Well, except Mr. Best is there, you see. That's why Home Affairs have taken him. In case he gaps it.
In case he took the gap.
In case he gaps it. But I mean, the point is, anyway.
No, I want to go further than this. So that's the first point. That's the first point. The second point on that. The second point, if you are insistent... Oh, sorry.
I just want to be clear in my mind that you say the second arrest took place on the 12th.
Yes.
When she was handed over
Yes.
to Miss Roy.
No, yes, it's a double barrel because it was... Yes.
So when she was handed over, the mere presence of the police there constituted arrest.
Excuse me?
The mere presence of the police were escorting Home Affairs people.
Yes, that's what they say.
Arrest.
Yes. No, what I say is this. To suggest, I've got two answers. To suggest that the police, as Justice Gordon could just be walking around saying, here we are, and look at the sun or the moon or whatever, the moon at that time of night, we would submit is an untenable suggestion or finding. Bearing in mind...
I just want to know exactly what the submission is.
The police were involved as much as Home Affairs in what happened on the night of the 12th in Tanzania.
She was arrested under those circumstances when she was handed over.
Correct.
She was arrested because the police were there, and it's untenable that they couldn't have been there just to walk around.
As it pleases the court. And if you reject that
suggestion... on South African soil.
Excuse me?
The third arrest was there on South Africa.
The third arrest was in Lansera.
So they,
If you reject the submission as far as the police are concerned, and you can, and the court finds that the suggestion of Justice Gorgon that the police were just looking around and waiting for action to happen, then
We don't know any different, do we?
they haven't told us.
No, well, we don't know.
Yes, because
she
they
didn't
don't-
say anything that was believed, because what she said was wrong.
I'll come to that. I will, Justice Gorgon, I will come, see, I haven't been, when I come to my pleadings argument, I'll deal with it. But if you reject it, even with after my pleadings argument, then I would ask that the court take out the 3 words in the second line of 2.1 of our order.
Sorry.
So paragraph in our order 2.1. But we said I'm not going to concede this at all. I will
sorry,
say-
in your order as per your heads of argument.
as the heads of argument. So it's on page 14, paragraph 2.1, there's a declarator, and the second line it includes,
Give us a second, please.
excuse me, so-
So which 3 words did you take out? I think you
of the second and,
You need this second.
the second and, of those 3 words. Sorry, the second line on 2.1,
Oh, so the and,
the second and.
yeah.
Because then you guys, the court would be giving our learned friends a free pass. There's nobody to defend the Home Affairs here.
Okay, so
Well, they were to the frame, but we get into the pleading bodies.
Yes. But I'm going to say the police are in the frame, but we'll come to that.
Sorry, I'm confused. Which second and? So the,
No, 2.1, the second line,
Yeah.
it starts with the word officials,
Yeah.
and then you take out the words the, second, and.
oh, take that.
Those 3 words out. That's if you reject my argument as far as the involvement of the police.
So then your case would be she was apprehended and arrested by officials.
I'm not saying that's our case. I'm saying if the court rejects my suggestion
Yes.
that the police were involved, then my submission is the court should nevertheless find that Home Affairs acted in the way that's described in paragraph
Home
2.1.
Affairs and we have apprehended her and arrested her.
Yes. That's if you reject my
Basically,
argument.
your case is that the Home Affairs was involved in the second arrest, not the third.
Not the third.
Not the third. It's not when she gave herself, not when she was.
But it's hard to say. The evidence is that there was a Section 43 of the Criminal Procedure Act warrant, which was waiting for it, had been issued in, I think, on the 6th of April. I think it's the 6th of April. And that it was executed when she arrived at Lanseria, and presumably those in whose custody she was handed it over once again to have that warrant executed. Who executed it, I presume?
Well, the Home Affairs had no jurisdiction to do that.
No, I've neither here nor there. But now please turn to the pleadings point, Justice Gorgon, because I think that does exercise my mind, because a lot of the debate has surrounded this question.
Right, can sit because of dinner for about 5 minutes? Yeah.
Oh, now continue.
Okay.
The pleadings point, I want to make a number of submissions. The first is, Justice Gorgon, you accepted it seems to me that it was accepted my proposition that in a case such as this, well, I'm not sure you did accept the proposition, but my submission is, in a case such as this, somebody who claims to have been in unlawful detention, and she chooses the wrong target as to who it is, can't blame her because she wouldn't know.
Okay, no,
But I'll come to...
I'll tell you what my understanding is this. Once you have proved a deprivation of liberty by that person you accused of having deprived of liberty, the onus shifts to prove the lawfulness of that deprivation to that person. But you first have to prove a deprivation of liberty.
I'm going to qualify what, if I understand your position, Justice Gorgon, to say what's got to be proven by the applicant is that there's deprivation of liberty.
Yes.
If she chooses the wrong target, who did it and the wrong date, that's for the respondent to say, it wasn't me, it was somebody else on a different date. But she says it was the police, she's wrong, so we accept that she's wrong. And then the court will do the following. This court and many courts have made this following point on page 44 of the little bundle. Have made this point, that in a case, generally, not in a case such as this, a general case, it can be a review, it could be an interdict of any kind where certain things are said in the replying affidavit. Let me emphasize this. Certain things are said in the replying affidavit. And the respondent normally would not have an opportunity to deal with that which is contained in the reply. But what is said in the reply calls for an answer, and there is no request by the respondent to deal with it, then the court will accept as a fact what's contained in the replying affidavit. This court has said it, and many courts, and it's very neatly summarized in paragraph 51 on page 44 by Murphy J. As these averments were made in the replying affidavit, the second respondent, strictly speaking, had no entitlement to respond, and the normal course they could be denied or explained by the respondent. Nevertheless, if the allegations by Ms. Peer were untrue, or if an adequate explanation were possible, leave of the court could, and we emphasize should, have been sought to answer them. See Sigaba. The respondents did not require to be given an opportunity to deal with these averments. Their failure to do so tilts the probabilities. That's paragraph 51, and the same proposition is in 71, paragraph 71 on the next page. And then if we turn to page 48, this court, Scutts J.A. said in Pretoria, Portland Cement, and it's been repeated, this proposition in a minority of Justice Nkobo in the Constitutional Court judgment of Tint. But it's a principle that we submit should commend itself to this court generally, and in particular when it comes to the questions of unlawful deportation, unlawful disguised extradition type case. It's classically the kind of case that this kind of idea deals with. What he said in paragraph 63 on page 48, the court will know what happened here was there was a raid on Pretoria Portland Cement Company by the Competition Commission, and the commissioner was Advocate Similani, and he said certain things and did certain things, and in the replying affidavit then there were certain allegations made by the attorney for Pretoria Portland Cement, and this is what Scutts J.A. said. The impression of publicity seeking is reinforced by Similani's uninvited media interviews held in PPC's own car park. There's another aspect of this conduct that deserves comment, and here we come. In his replying affidavit, Gomersal stated that the book kept at the entrance gate reflected that at 12:40, Similani had signed and stated, "Whom visited? MD." Gomersal added that it was simply untrue. I just want to emphasize, in our replying affidavit, we look at what the respondents say and we say it was simply untrue, and then it goes on for Similani to have said that he intended visiting the managing director. And we know from one of the commission's witnesses that the meeting in the car park was prearranged. Now this is the sentence that we would commend to this court. Now it is true that Similani had no right or duty to answer this allegation made in reply. But Scutts J.A. says, I would have expected him to offer to do so if Gomersal's imputation of dishonesty were false. So what happens here is we say what we say in our founding papers. I cannot get away from Justice Morgan. They put up a version, they being the police and home affairs. In our replying affidavit, we say, hey, look at what they say. This is an unlawful disguised extradition. I've never seen my prohibited immigrant paper, etc., etc. And what do we hear in response to the reply? Nothing. And we submit that this court should say, as Scutts J.A. said, yes, the respondents had no right or duty to answer, but this court would have expected the police and Home Affairs to offer an explanation if the dishonest disguised extradition suggestions were untrue, were false.
The difficulty with that, though, is that both of the cases you referred to us were evidentiary issues which should have been dealt with. In other words, the person should have said factually this or that or whatever. What we're attempting to do is found your case on the answering affidavit and then in the reply say, oh, well, but actually that's a disguised expedition. And I don't think that's on the same footing as these matters.
Justice Gordon, I know that my learned friend will try to argue till it's signed, and I've got two answers to that. That's the kind of idea that I'm hearing from you, Justice Gordon. We submit that Teletsani itself, the ratio in Teletsani, the kind of dicta that follow the ratio, supports us rather than on this argument that I'm now making. And that I ask that the court have regard to what Botha J.A. said, It's 197 from E onto the next page. I'm not going to read it now. 198. That's one.
Are you referring us to which case?
Teletsani. Teletsani. And there's another case.
All right, with that, can we just take that?
Yes, please. Yes, yes, yes.
Maybe possible.
As a please.
Maybe